the decades. We are in the 250th year. We're going to be celebrating the 250 anniversary, birthday of our country, and that's very exciting. So in the meantime, we have people that care about our country. I do. Our frequent guest, Larry Beecraft, attorney from Alabama, is with us. Larry has donated, I don't know, a few 100,000 hours to the cause of freedom, maybe more. And we have Mark Lucas with us as well. And so we're going to start with, Mark had reminded us that there were some questions from the past that we haven't really addressed. So Mark is going to help pose those questions, and then either Larry or Mark or possibly myself will try to answer them. So with that, Mark, take it away.
Yeah, hi. Good evening, everybody. All right, so we left a list. I sent a list last time to Larry. So some members of my group, the Telegram group, asked certain things that I would like to address. And I know Larry doesn't necessarily like to answer these type of questions because they are what about me kind of a thing. And this is not, I guess Zoom calls are not one-on-one legal advice. It's not advisable anyway. But still, let's address them. Let's start and see where it takes us. One of the questions was, what's the best way to get employees to stop withholding? I'm going to lay them out so you get a general idea of where this is going. Number two, if we are successful with not filing, will state tax authorities come after us? Number three, if we received Affordable Health Care Act subsidies for affordable health care insurance for a year, we do not file a federal tax return, how do we respond to the request for Form 8962 that is required to be filed with a federal return so they can do an accounting toward determining your AGI? Number four, what is the effect of the LT26 if unanswered? And we're not familiar with that. I'm not familiar. Maybe Larry or Joe is. And number five on this list is, what is the chain of events to trigger the lock-in letter? So I'd like to take the first shot at this. All these questions, excuse me, are administrative in nature, meaning you've done something that brought you into the administrative regulatory or crosshairs of the agencies, be it IRS or the state. The first question, best way to get employees to stop withholding is...
Employees or employers?
The employees. The best way to get employers to stop withholding. It's employees here, but I'm sure it's employers to stop withholding. So that is what people like David William, Dave Champion, and even Thomas Freed and Paymon, I think, are offering letters trying to communicate between you guys and the employers, or even business cooperators or collaborators, so that they don't give you a W-9 or a W-4, which then are followed by the W-2s and 1099s. So that is not something that we found to be long-lasting, or in my experience, everybody I dealt with, yes, it might work in some instances. You get an employer that is more lenient and say, okay, let's try it. But eventually, sometime down the road, because the employer will have to claim some deductions, at least that's what they think they have to do. They don't realize they can do that without having to give you or get you into this game. And eventually, IRS will catch on, and something will trigger the computer. And after IRS, also the tax agencies, because the employer will send some information as their deductions regards to you and your social security, and that will trigger the computer. So that's why administratively it's a a short-lived success, if you want, temporary. Number two is same category question. If we are successful with not filing, will state tax authorities come after us? I think that's asked and answered already, pretty much. If we receive affordable health care, subsidies for affordable health care, well, you took something, and there's a case where it says the case may ask return on that which they have provided. So if any government, you go your hand out, they're going to give you something, they make the rules. So that's logical, I would say. That's my position, at least. This is my answer, unless Larry has a different opinion. Number four, what is the effect of LT26? I don't know what that means. And number five, what is the chain of events to trigger a lock-in letter? And technically, I think this one, Joe would be more technical about this, unless Sherry is with us as well tonight. Joe, you want to take that question?
As far as the lock-in letter?
Yeah, what is the chain of events to trigger a lock-in letter?
Well, I haven't dealt with a lot of them, and I've heard about it, how it goes. So I guess I'll just recount as best I know. Probably somebody like a Paymon with Freedom Law School has dealt with hundreds of them. But basically, we all know, I'm sure the audience and we all know that the withholding is a scam in the sense of making you enter into this voluntary withholding agreement to have money withheld from your paycheck. I also know personally from when there was arguments in my own criminal case about what withholding actually does. The money that's withheld from your paycheck is not a tax. It's a withholding against a future tax. And maybe, Larry can correct me if I'm wrong, but
That's correct, Joe.
they actually made motions, back and forth between the prosecutors and my defense attorneys on that point. But that's kind of a side issue. Anyway, so those that would like to have the truth be known as far as their paycheck will say, hey, I don't want withholding. And of course, a lot of businesses think that withholding is required, and they don't understand how it comes about, or how they can operate without withholding from your paycheck. And even if you try to explain it to them, they talk to their CPA or their lawyer, and they're like, oh, no, you don't want that kind of trouble. But for those that use what's called an Exempt W-4, they basically figure out that one of the avenues which can be effective is, and I'm not going to comment on whether you're taking some risks, but I mean everything's a risk these days. Anyway, so if you file an Exempt W-4, typically that will stop your federal and state withholding. How long that will occur is another question.
I heard 2-3 years.
Yeah, it kind of depends on how much you get paid, how the workload of the IRS, whether their computers are working or not, how well they're working. It's really kind of a crapshoot, but typically it does stop withholding as far as I can tell. Anyway, at some point through the IRS computers getting triggered, or the business, making an inquiry of the IRS, or another worker there who's like, hey, how come you get to not have any money taken out of your check, but I still have to take it out of mine? There's different ways that it can be triggered where the IRS starts to scrutinize what's going on. And so if the IRS begins the scrutiny process and you are a person who did successfully get federal and state withholding stopped, the IRS will issue what's commonly known as a lock-in letter. And again, Mark and Larry can correct me if I'm wrong, but my understanding is that the IRS, as is typical of the IRS, they have zero statutory authority to be ordering a business to withhold from your paycheck. But has that ever stopped the IRS before? Right? I mean, the IRS and the DOJ prosecuted me, and they had no case against me, but they still put me through it. So, in fact, they do not have the authority to issue these lock-in letters. But what a lock-in letter means, or the reason they use the term lock-in, is that the IRS orders the business to lock in a single zero withholding status. And single zero, most people are probably aware, is the highest withholding that they can muster against you. So not only is the lock-in letter, they don't have the authority to do it. The business, if they knew better or they had a bit of a spine, they could say, well, put up or shut up, IRS. Thanks for this letter, but show me the actual authority that you have to order me to do this. And of course, the IRS isn't going to show it. But typically, the business will comply with the lock-in letter. And where you had been successful in stopping withholding for 6 months, a year, several years, if the business receives a lock-in letter from the IRS, you can expect that the business will treat the lock-in letter like it's gospel, and they will begin to withhold again at single zero, meaning the highest possible withholding they can take out of your paycheck. And then I'm not really aware of any success in, people that have taken it to court. Perhaps Paymon with Freedom Law School has done so. I just don't know what the success rate is. I know that they just don't have the authority to do it, but the IRS does it anyway. So hopefully that was fairly thorough. That's what a lock-in letter is.
That was great. That was great. Thanks, Joe. So my experience has been that everybody, because I go to several groups, everybody would prefer to have the solutions done administratively rather than having to go to court and expenses, etc. And that's what these organizations, promoters, have more or less promised. But I'm afraid that once you are in what I call it their sandbox, it's quicksand from that point on, because they can do whatever they want. And even though with the letters that someone like Freed or Paymon or Champion or anybody else that does this and creates a record of lack of willfulness based on, hey, I read this, I understand this, I'm not sure I do it right, whatever. So they prevent being prosecuted criminally. That there's no guarantee that the agencies, be it IRS or state, would not go behind your back. It'll go to the employers or business partners or whatever. And eventually they'll give in and they'll get your money, or they'll go to the bank. They'll put a block on the bank or do a levy, because the process starts. And the people in the IRS are not trained to provide what we'd be looking for, justice. Hey, listen, this is me here talking to you. No, they don't care really, because that's their job. I mean, you're asking them to basically terminate a means to make a living. So I don't think that is in their best interest, and I don't think that the system is set up as such. And that's why I doubt that administrative remedies are really effective. The effectiveness of an administrative hearing or process or tax court might be if indeed you overpaid something, then to, yes, recuperate some of that money according to the overpayment, according to their the standards of taxpayer liability. So you're a taxpayer, you are the one going to tax court. Tax court considers you a taxpayer. They're not there to impart justice. They're there to discuss the numbers that the IRS or state tax agency has, and to analyze whether or not you owe more or less. That's my understanding of how this administrative process works, which is why I was so curious about what David William process said, because I saw with my own eyes, and everybody in his group saw, at least 4 or 5 transcripts that were zeroed out about 3-4 years in existence by now. And he claimed to have done this for 9, 10, 11 years, and he did it for his own wife. But as of lately, we've learned that this FTB, which is a state of California agency, for those who don't know, started denying the refunds and claiming them back. And they ended up suing the FTB for these refunds, and they were not successful. They took it all the way to the Supreme Court, and the Supreme Court would not hear them. And so that kind of faded in the dark. And people now are left without any leadership in that 1040 NR filing, because David William up and went, disappeared. We don't know why. We don't think he's done anything wrong necessarily, but maybe he was attacked or something like that. Anyway, so the next point was I wanted to touch upon. Larry has introduced us to his site and asked people to read. And I got a reply from someone that did their homework, and here's what it says. I have been reading the 1913 Tariff Acts and 1916 and 1917 Acts for several hours today. I do not see the connection to NRA, non-resident alien, and foreign corporations as the sole object of the tax. Section 2A, subdivision 1, it states as a tax upon the net income. It is stated as a tax upon the net income from all sources to every citizen, whether residing at home or abroad. Net income and all sources are not defined, which means the dictionary definitions must be used, correct? And then follows up with, other than the withholding provisions applying to NRA and foreign corporations in the modern Title 26, I do not see how these can be interpreted as not applying to us citizens earning wages. What am I missing? Help me see what Larry claims in his article, Simple Truth, when he says it goes back to the 1913 Act. So I didn't want to answer this because I wanted to give you the opportunity to do this, and also to respond to those who are concerned when they read about the fact that in Re Beecraft, you were sanctioned some money for a particular case or another. But that's the second thing that I want to discuss, and then I'm done. So which one do you want to tackle first, Larry?
Is that a question to pose to me?
Yes.
Okay. I think I said the first time I was on these meetings that there are basically 3 patterns to the income tax. You have a period between 1918 and 1928, that's one period. From 1928 through 1954, that's another period. From 54 forward, that's a third period. The reason I have broken them up into these categories is because basically this income tax, the federal income tax, has had 3 different formats. Now, the reason I exclude the stuff before 1918 is because all you have is the 1916 Act and 1917 Act. Those were beginning income tax acts right after the Supreme Court came out with a decision in the 1916 decision in the Bruchager case. When you dig into those tax acts, you know, the way the income tax is structured, the way it's all connected, I think I said a couple of these sessions ago, the 1986 Internal Revenue Code is nothing more than the 1954 Code, renamed. The 1954 Code was adopted in August of 1954, and it's nothing more than the reshuffled and renamed 1939 Code. Now, anybody, in my view, anybody that's going to try to come to an understanding about how the income tax operates needs to know how there's this interrelationship. And the reason I don't try to deal with 1918, 1916, and 1917 is because once you understand this in lieu of feature, 1916 and 1917 are no longer irrelevant. What you have is, for a period of time between 1918 to 1928, you have one format. And then they pull some tricks, and then from 1928 through 1954, there's another format, which is the format for the 1939 Code. Then after 1954, you have the third format. Now, it's real important, and this is what's so blooming difficult. That's the reason I have provided all the old tax acts. You got to understand that there's this interrelationship. And once you find out that there's this interrelationship, you start following it forward, you can see how the income tax has been constructed.
So are we to understand that the 1913 through 1918 is?
You can study them, but it's irrelevant for our purposes of trying to find out how does the income tax work.
Because they've been what? They've been canceled out. They no longer.
No, well, you can say that they've been canceled out, but it's the same. The same scheme remains in effect, but everything's in lieu of. That's the reason why I think it's real important. I've talked to people on our side of the camp, and the people in the tax movement, and tell them, well, you got to go back and take a look at this old stuff. And they refuse. No. The only thing I need to know is the current stuff, which is dead wrong.
Right. So
it's so blue. Is once you pick the Remedy Act of 1921, and you don't have to be. You don't have to be a scholar. Just look at how it's structured. And once you see that, like the Revenue Act of 1918, which is the first one right there at the top of the page, it'll say, in lieu of the previous tax, there is hereby imposed this tax. And then in 1921, they say, well, in lieu of the tax imposed in 1918, there is this tax. And then 1924, they say, in lieu of the tax imposed in 1921,
right. And we understand that, but it's specific. It's specific to the citizen. I think that's what triggers this question.
Well, what's really important is knowing about liable, and having knowing. That's the reason why I like for the 1939 Internal Revenue Code, and all the way back to 1928. Who's liable has always been the withholding agent for non-resident entities and foreign corporations. That is the same way it is today. You can try to find a section of Subtitle A that makes anybody liable for the income tax, and it's only Section 1461, the withholding agent for non-resident entities and foreign corporations. And once that's the reason why you don't have to know exactly how all these old tax acts operates. Just following forward the major features of it, particularly who's liable for the tax. Get that under your hat. Have a good command of how that all interrelates, and then that'll be getting you further down the road to understanding, how this sucker operates. Because there's a lot of tricks when you get into this. But one of the biggest tricks you got to understand is who's liable for the income tax.
Right.
And, like today we have 6001 and 6011. 6001 and 6011 say those that are required to file a return are those that are liable for tax. And that's the way it was all the way back under the old tax acts. There was a section, you got to be liable for the tax, and then there's somebody that's made liable. It's the withholding agent. So understanding this feature is real important. knowing that the only party that's been liable has been the withholding agent for non-residents and foreign corporations. And then you go see who's liable. And the withholding agent is as much as the system doesn't want to acknowledge this. As a matter of the way this thing is structured, that is the case. And once you reach a point where you understand how it works, there's a grand scheme that you can picture in your mind, and that's the way it's been for ever since 1916. So even though you have people saying, "Well, I've looked at 1916 and 1917," well, why don't you move on? Why don't you move on and see, well, gee, in 1918, the tax was imposed in 1916 was cast aside, and that same scheme moved forward. But when it moved forward,
there's no clear language that says. So we actually have to kind of arrive at the fact that there's no clear language that says only NRAs and foreign corporations.
Yeah, it doesn't say that.
So they don't specifically say that such, right?
Right. And you got to see the scheme. And once you understand some of the basic features, once you have that in your mind, knowing that it's all interrelated, you like. Let me give you an example of how they trick things. Create these little tricks. In 1928. They continued basically the format that they had before. It's the withholding agent for non-residents and foreign corporations is liable for the tax. But this time, whereas that you could see that in the tax imposed section, they divided it up. They split the in lieu of feature and stuck it over in section 63. So that's the way that they have this format. And then they manipulate things they still keep the same format, but they make it a little bit more complicated, like splitting a section up, sticking it over someplace else. But it's a critical part of how the thing works, and that's the reason why I think it's real important for people to understand a basic format.
Right, but what's hard for people is to arrive at the same conclusions that you have arrived, because you have arrived at this after reading all this material, and you had acquired a vast amount of knowledge, and things jump out to you after so many years of study. And it's not as obvious to the first time reader.
I understand it's not as obvious.
Right. So is there any way that maybe we can do a session, one of these Zoom calls, maybe the next time, where you give us like one example? Let's say we go to that 1928 Act and you kind of point out a few things. Maybe we work on a PDF document with a highlight to kind of give people an idea how to research this thing, because they are overwhelmed and they're intimidated by this, and they say, "Oh, the hell with it," it's normal. I think that's a normal reaction, and maybe we need to do a little bit hand holding for the first steps or two in this research. Because
I'm more than happy to do that.
Okay, great.
Because, hey, let me. I've been at this for decades. And there's really two ways for us to get this accomplished. Either the people that are interested in doing something about their own personal situation, either they've got to do the research, either they have to, do all the study, or they're going to have somebody else do it. So which is it? I've just seen too many people over the years, well, I want to dig into it. Well, after they start digging into it, well, it's a little bit different. Now, now I'm having to dig around. That's when people fall off.
So could we show them? Could we just show them, like with the Revenue Act of 1924, or like?
Pull that up.
Okay.
Right. While Joe is looking for this, okay, you got it.
No. Okay, all right.
Should I go?
Hey, Joe, do you have that disc?
Well, but isn't it also here at the Constitution?
Oh, yeah. You're right. Okay. On the Constitution website.
So
okay. Click on. See the 1921.
Yeah.
Okay. Click on 42 Stat 227.
Why do they not put the year next to the 42 stat? To make it difficult?
No,
Line 1920.
well, because that's where you need to know a little bit about how the statutes at large are published. There's just one act of Congress right after the other. Now, here's the 1921 Act. Now, here at the beginning, you have these definitions. And general provisions is part 200. Let's move on down, Joe. Dividends, we don't need to deal with that. I think it'll be section 211 before we get into anything of substance. Yeah.
See, the average person out there would start reading this, not realizing that they need to get down all the way to section 211 before they get into some meat.
Well, it'd be
Something meaningful.
section 210. Section 210.
Okay.
See, they had them. They divided the tax up into two separate categories. One was the flat rate, a percentage of a flat rate, and then graduated. Now, the reason why I think they did that is because, if you go back and read the Bruce-Jaber case, one of the issues in the Bruce-Jaber case was an attack upon the graduated income tax. And so when they started out, they said, well, somebody may be attacking us constitutionality on, having progressive graduated income taxes. So they had one section just to provide for a flat rate, and then another section providing for the progressive, graduated income tax. So that's the reason why that was done. You'll find out later on they quit doing that. But here you have the normal tax. So Joe, go on down.
Before you go, Joe, hold on one second. See, the average person would read individual, and that's them, and they see the net income of every individual a normal tax. So they're going to think, oh, okay, well, there it is. That's me, net income. That means gross minus. How do I know that's not me? How do I know that's non-resident alien? See what I mean? That's what we need to kind of help people bridge their understanding from why they cannot conclude that this is about them.
Well, one of the things, I don't know whether we talk about it in a previous email, about how do you get a taxpayer identification number?
We touched upon it, but the thing is that people do not equate taxpayer identification number with the Social Security. To them, in their minds, is a separate thing. These are two different things. So they don't think that when you're talking about taxpayer identification number, you're also covering the Social Security number.
Well, have you got those forms available? I don't have them in front of me.
I do, but I don't know if Joe has them. You're talking about a W-7?
Yeah, W-7.
I'll look it up. Meanwhile, anything?
This just here we are on individual, and an individual, under today's law, and I would suggest it's all the way back, but an individual is a blooming is not a citizen. That's for damn sure.
Right.
And see that's where you have to, there's these little points like that. They cause some people some problems when they first start digging into this.
Right. So I think we need to kind of point these things out in our sessions and say, okay, we made a statement. Individual does not mean what you think it does. So let's take for 10 minutes, 15 minutes, and let's set this up for next time. Let's say individual 10, 15-minute presentation of why it doesn't and why this individual, for the purposes of subtitle A of income tax, is a non-resident alien.
Well, here's the problem I've got with that, Mark.
Okay.
Here's the unrestrained, hey, I've got to do this right now, and people, when they learn something, boom, tomorrow morning before 7 o'clock, they're going to be putting it to work. And that's the greatest killer of issues, You know, we're dealing with legal matters, and people are so ready and willing to just go charging off completely unprepared. And, that's been a big problem that I've encountered over the years. I'll give you an example. I don't know whether since we got some kind of new people here, let's go back to John Kottmeyer. Decades ago, back in the 90s, I got in the 80s and 90s, John Kottmeyer was the head of a group up in Maryland. And, he would try to teach his members about how to do their own battles legally. And, his presupposition, hey, here is a brand new, I'd come up with an argument and present it to him. Oh, I've got to tell it to my members. And then the members, just wouldn't have any real command. Oh, I can at least restate it. They don't understand it, but boy, they'll be throwing it. And that's what's happened to the tax movement. We just got a bunch of people that are, I'm on a tripwire. And I get something, boom, I'm going to immediately use it. And once they got run into a problem, they don't know what to do. And so rather than carefully planning what we're going to do, we've had a whole bunch of people on our side that have killed a bunch of good issues. And this issue of what's an individual, I'm just kind of fearful, but it's kind of simple. And, a little bit of seeing it is from those blooming forms.
Right. So basically what we're telling them tonight is that we're cautious. We're really pointing out things that will become obvious to them out of fear that they may take this on their own. They may end up some kind of litigation and establish some kind of case law precedent that will throw a monkey wrench in our equation here.
And and people will take this W-7 form. What? This is the answer. And it's just a simple little thing. And people will think, boy, this is it. And they go, I guarantee you that if this got out, there'll be a sizable segment just talking about it, and they'll be charging off. I got to go tell my employer. This is the only issue that they know. So they immediately throw it. And it's going to get destroyed.
Okay, so we're not proposing that through these Zoom meetings we're going to have a legal or law school or educate people to how to litigate. Basically what we're trying to do, if I understand this correctly, we're trying to make them aware that there are certain things that are extremely valuable that we pretty much know they will not be able to handle on their own. We advise them against it, but in order to gain their confidence that we know what we're doing, we kind of have to let them in, show them a few things to realize that there's more to this than meets the eye. And if properly handled, and if they're willing to be part of our group, then we can create a common effort to finance the projects that we want to finance on multiple fronts, which are probably 6 or 7 projects. Last we discussed about this. Is that correct?
Yeah.
Good. Now, I had an email somebody sent and forwarded and said, hey, how about this? And here's what it reads. In Re Beecraft 885 F7 second whatever, the court imposed monetary damages on Beecraft, an attorney based on his advocacy of frivolous claims, such as that federal lawsuit apply only to United States territories. Federal laws, apply only to United States territories and the District of Columbia, which the court found had no semblance of merit, quote unquote. Would you mind addressing that?
Yeah, I'll address that. There's some cases back in 1901. Before that time, we were running around acquiring a whole bunch of territories, the United States. How about Hawaii? 1898. And so the issue came up. There's 2 real important United States Supreme Court cases that relate to taxation and the possessions. And that is very, when you go through these tax acts, like we were on the Revenue Act of 1918, once you get back into the sections 230, around there, you'll find that, boy, they're very specific about taxing. And in fact, the only place where they specifically talk about taxing the citizens is in the possessions. Go look. So, just that case, here's, let me tell you about that case, in the Nelson case. That was a case tried in Nevada. He got convicted, went up on appeal. Now, back in those days when we tried that case, I think it's probably about 1990, and that was hot back then, those days. Jurisdiction. Why was it hot? Well, I've been teaching for about 4 or 5 years the freedom movement about Article 1, Section 8, Clause 17 jurisdiction, because in the mid-'80s, and this is on, if you get that flash drive, a scan of this 1957 jurisdiction report is on there. And, I had been, if you go over to my website, there's a big segment of my website that's related to Article 1, Section 8, Clause 17, jurisdiction. And, you do have a bunch of cases that say, and if you want me to give you cases that say it, there's probably in these, I haven't looked at this section here on jurisdiction before, but I think that if you look at the brief, there's a legal principle that the laws of the United States are inherently territorial. And the courts don't want to deal with that issue. There's, the jurisdiction of the United States and that 1957 government report on jurisdiction, and there's more than what I'm talking about right now. But, it's real important. And the judges don't like the fact that, well, gee, here we have cases themselves that they have talked about when they're talking about Article 1, Section 8, Clause 17 of the United States Constitution. They themselves say, next time I will get you the case. It's a Fifth Circuit case, Cleo's Funkies Express. Cleo's Funkies Express was a band. They played on military bases. One time, this band, Cleo's Funkies Express, rolled into a military base in the Fifth Circuit, and there was a burglary of some equipment. And so the defense, when one of the band members was charged with theft of a piece of equipment, they were making this argument about, gee, these jurisdiction principles have application to my case because I am dealing with a theft that is based upon a military facility within the federal jurisdiction, Article 1, Section 8, Clause 17. And you read some of the quotes, read some of the statements of the courts in that case, where they're talking about, well, gee, and a number of other federal courts come along and say, well, inherently the laws of the United States are inherently territorial, jurisdictional. They don't want to deal with their own statements. And when I come along and try to throw their own statements in their face, they don't like it. And that's what I was doing with the Nelson case. His defense was, this was hot back in those days, that the federal income tax laws, in conformity with statements made by federal district court judges, circuit court judges, about the laws of the federal government applying within the territorial jurisdiction of the United States, that's what they were saying. So, okay, well, we haven't really had anybody make a challenge to that in reference to the income tax, but I'm going to believe that. Now, I have prevailed on this issue of, a requested jury instruction to embody my theory of defense. And I've got this, if you go over to my website, I've got this case posted there. But I was defending a guy that was charged with bribery down here in Birmingham, Alabama. Can you back out of this one? Okay. let me see where this will be. Well, let me tell you about theory of defense jury instructions. I got a conviction, and it's got a reversal of a conviction, and that case is posted on my website. But it was a case where this guy was charged with attempted bribery of he owed something like $150,000 in taxes, and there's a guy down in Birmingham, a crook, who said, I can get this satisfied. Give me some cash, and I'll go visit the agent that's trying to collect this, pay him, and you'll be free of your tax. Well, my client did that. And when he came to Birmingham with this whole bunch of cash, they met in a hotel room, and it was all videotaped. And he was charged with bribery. And so my theory of defense for my client was, well, the law does allow you to enter into compromises of your tax liability. Well, that's a theory of defense jury instruction. And so I submitted that request in black and white. Hey, judge, it's perfectly lawful for you to enter into compromises with an IRS collection agent. And the judge didn't give that jury instruction. And that is what's called a theory of defense jury instruction. So from a denial of that requested jury instruction, I went up on appeal to the 11th Circuit. The 11th Circuit reversed the conviction. So that's called a theory of defense jury instruction in criminal law. Now, that's exactly what I was doing in the Nelson case. There's a theory of defense. There was a theory of defense, a valid theory. You got to admit, there's a whole book written on this. That the jurisdiction in the United States is constitutionally described as the territories, instant possessions, and the tracts of land, the governmental tracts of land inside the states for which the states have ceded jurisdiction to Uncle Sam. Those are the federal enclaves. And, the cases say, well, the territorial jurisdiction of the United States is Washington, D.C., the federal enclaves in the states, and the territories and instant possessions.
And that's what all these non-resident alien advocates use. They say, because of that.
That's perfectly valid. And so in the Nelson case, I was making, hey, look, my client believed this. This is part of his tax belief. Well, as theory of defense, I'm entitled to the jury being informed of the law that supports my defense. And so if you have somebody that's got a belief about the jurisdiction of the United States, it's Washington, D.C., federal enclaves in the states, and territories and instant possessions, that ain't false. That ain't wrong. That's what the courts say. That's what a book says. And that's called a theory of defense. And so what I've learned over the years is that, you can come along and some of these unpopular
arguments,
flaws, some of the weaknesses of the federal government, they don't like to talk about those. But generally educating people, I can remember talking to people that have been prominent in the movement, and they were never aware of, gee, what do you mean the jurisdiction of the United States is that limited? Doesn't the federal government have jurisdiction everywhere? Well, what do you have to say about these statements of the courts? What do you have to say about this statement of the government in a book? So, and this is just a minor explanation for that case. One of the things, and this is, Mac McPherson, a bunch of other criminal defense attorneys, Barry Gibbons, we've rolled out and presented. It's clearly unpopular with the federal government. The government doesn't like having its panties exposed, the weaknesses exposed, because those weaknesses could hurt it. And I'll tell you this. Once you really understand the income tax, and there's certain parts of it I'm not going to publicly disclose, but I've dug in and spent time to figure out how it works. And the government doesn't like how the income tax works. Legally, it likes having the public believe something is wrong. The income tax applies to a far bigger class of people than it really does. And so, if you're believing that, you're very, very unpopular with the government. So, and I readily admit that I've been unpopular with the government. Why? Because I'm firmly convinced, and I've studied more. I've studied more about the income tax than anybody in the government. I don't know anybody in the government that's read all the tax acts. I've been in court and asked these agents on the stand, well, have you read the old tax acts? Have you read the old regulations? And they haven't. And that's where I've learned, hey, the people that work for the government, the people in the IRS, they just have somebody else that's read a manual teach them what the manual has to say.
Right.
Yeah.
So here's a simple question. So if the Section 1461 deals with withholding agents, does that make an employer a withholding agent?
Let's go. I wanted to say this at the very beginning. So, Joe, go back to the document you had on the screen, where they lists all the people that are attending this meeting. Get off this, and there's one guy I'm going to target. Yeah. Let me see. There's somebody on here that, I'm going to terrorize, okay?
Topster?
Golly, you read my mind.
Well, he has his hand up, so let's see if I...
Oh, he does? Oh, golly. Okay. All right, I'm going to give Tapster a task.
Can you give me just a second? Well, go ahead, Larry. You can give me the task if you want to, but I've had my hand up since that very first question.
Oh, well, go ahead and ask the question.
Well, it's not. I don't have a question. I've got a statement. They were talking about going back to the 1924 acts, and they were reading all this stuff, and they were coming up with a lot of stuff, and they were having a hard time understanding it. I recommend, and I've done this for quite a bit. And Joe, if you want to let me show my screen here in a few minutes, it might be beneficial. But if you go back to the 1861 Act and North Central Railroad v. Jackson, that will give you a very good understanding of associating what the liability or the tax is levied on and how the courts interpreted it back in at the time of the original Tax Act. So, I mean,
a Civil War income tax.
I'm saying that's what I'm saying. Go back to the very first one, because North Central Railroad v. Jackson. It couldn't be any plainer. And we did this with Gary Tomlinson and stuff when y'all were doing these years back. And I was not aware of North Central Railroad. When Gary mentioned this, going back to the 1861 case, it just throws a light on how this thing can be read. I would assume you would agree with that.
In my flash drive, is that case mentioned down at the bottom?
It probably is. I've got all this stuff I've put together over the years after listening. But if you want to, Joe, would you let me share my screen for just a second?
Tapster, while you're looking for that, I had people that argued against that, said that, well, 1861, but the 16th Amendment changed all that.
No, it didn't. The 16th Amendment granted Congress no new powers of taxation, period. Period. And that's said that, and Bruce Shaber said it. It said, well, the federal government's saying they got all this new power. And he goes through and we'll show them how full of shit they are. Pardon my terminology, but that's the way I shorten it up. And then you go to what was the case that was decided the same day?
Stanton.
What was it?
Stanton.
You go into Stanton, and Stanton said the 16th Amendment granted Congress no new powers of taxation.
Right.
Yeah, I mean, I understand what you're saying, Mark, but all I'm doing is responding to the very first question when they were saying, I don't see it from the 1924 Act.
Right.
You know, and you got to go back to the very beginning to get a really good picture of what is taxed and what the federal authority is. Larry's talking jurisdiction. Well, what did Madison say in 45? Powers delegated by the proposed Constitution to the federal government are few and defined.
Far between.
Say what? Say it again.
Few and far between. Isn't that
Are few and defined. I think I've quoted it directly from my Federalist paper. But anyway, those acts which would remain with the state governments are numerous and indefinite. The former will be exercised principally, the former, the federal, on external objects where the federal government has authority, as war, peace, negotiations, and foreign commerce, with which last the power of taxation will, for the most part, be connected. So there's day one of the father of the Constitution kind of saying, we got these big boys up here in D.C. and this little 10 square miles. Well, it wasn't D.C. at the time. It was in Pennsylvania. But they have this authority. They do not, they can't just go into the states and look at what's going on right now. What are the states raising the ruckus about? Hey, federal government ain't got authority to come in here and send ICE in here and get rid of all these people, which is wrong because the Constitution does give the federal government the authority to handle immigration and naturalization. But anyway,
Before you forget, Larry, what was the task you wanted to give Tapster?
Oh,
yeah. Well, no, let it go on. But I mean, it is 9 o'clock, so I don't know how much more.
I do have one other question. I mean, Mark said that they're doing meetings. Are they doing something separate from y'all's deal, Joe? And if they are, how do you get informed of what, where, and how to get involved with that?
Mark, these other meetings that
yeah, we have a Telegram group. It's called No Mass Tax Chat.
It's on Telegram, and it's Telegram, and it's what?
Like no mas, like
no mas, NOMAS tax chat, no mas tax chat. And there's a good question here that says that if you're an American, your social security number is your taxpayer identifying number. Therefore, you don't need to submit the W-7, and that's addressed to Larry.
And I would suggest go look at section 6109, 6101 of the Internal Revenue Code, and the regulations.
Regulations. Yep. But. And I agree, but I do want to find out what y'all are doing outside of this meeting, because I think I might be able to add something to it. And I've done some work that might be beneficial to some of your members, but you need to have access to a computer. I mean, Zoom is a better way to do it.
Well, we do it Telegram because it's instantaneous. We can have instantaneous calls. We can transfer immediately documents, and people can talk amongst themselves without my direct participation. I pretty much
You set up the Telegram channel, Mark?
Yeah, I did, and I've just administrated their communications because they were abandoned.
Did you used to use something besides Zoom to communicate with people? I think you and I spoke probably 5 or 6 years ago when I think Gary Tomlinson was still alive. I think it was when
yes, it's possible. It's entirely possible. I talked to thousands of people. Yeah.
Yeah, I think we did speak.
What I'm going to do, I'm going to try to figure out how to put a link, an invite link on chat here for those who want to join our No Mas Tax chat.
Yeah, type in at least that again.
I'm going to try to do that. Give me a second to figure this out.
Meanwhile, Larry, you want to talk about those cases at all? Or?
Yeah, that's like the hour.
Okay.
During the course of this meeting this evening, some people have made some statements, giving me the impression that, that there's this belief on their part that, gee, Uncle Sam's got, authority over every square inch of America. And, I think it would be beneficial if people engage in a study of two cases. And let me explain the two cases. One is from Hunts Patch, Alabama, the place where I live. Back a couple of years ago, Congress had laid a kind of a statutory foundation for this, to authorize the IRS. And you'll notice that the way the Congress acts in reference to, everything that the Treasury Department does, it sets a non-operative. It doesn't mean it establishes a legislative background for a scheme. And then it authorizes the Treasury Department to write regulations to implement that scheme. So, one of these schemes is currency transaction reports. Back in the early 70s, Congress comes along, passes a law, which authorizes the Secretary of the Treasury to implement regulations to require the submission of reports regarding cash transactions. And so, there was a battle over the constitutionality of that in the early 70s. But then if you sit down and take a look at this is in Title 31, Code of Federal Regulations, and today it's now in Part 1010. There you have this framework for currency transaction reports. And so, and really, if you sit down and if you really study the law regarding these currency transaction reports, you'll find that, dang, I get all the time these reports. We're having a bunch of lawyers getting together, and we're going to have a seminar. And send us your $200 and you can participate in the seminar. We're going to be talking about these currency transaction reports. And, the people that kind of think that those are something important, there's law that applies to that transaction that they don't know anything about. Now, the same thing happened, here within the last couple of years. Treasury comes along and says, well, we're going to give the old Secretary of the Treasury the authority to require reports of beneficial ownerships in businesses. And so the good old Secretary of the Treasury, today it's Besant, who also happens to be the Commissioner of Internal Revenue. This law authorizes regulations to be written to require corporations and businesses to report all the beneficial owners in all of their businesses to the Treasury Department. And so, here you have the statutory foundation for that, which doesn't impose anybody to do anything. What it does is it authorizes the Secretary of the Treasury to promulgate regulations that require that. And so, over the last couple of years, that's been done. It was done before 1924. And so there were some lawsuits brought, which, I've tried for years to convince people in the tax movement, well, let's do something, like other people. When people have a difference of opinion with the Treasury Department, there's a lawsuit that gets filed. But, what most people in the tax movement want, they just want to wave a magic wand and have a problem go away. But, it took some work for, one of these cases was here in Huntsville, Alabama. And a lawsuit was filed challenging those regulations that the Secretary had come out with, requiring reports of beneficial interests. And, wow, I thought the federal government, you mean the federal government? You had two courts? After two courts found this to be unconstitutional, Treasury dropped it. And so what I think it would be beneficial for our attendees to do tonight, I sent them to Joe. PDFs, they're the actual decisions off the, as the judge filed the printed order from these two cases, one in Texas, one here in Hunts Patch, Alabama. One is the Texas case is Top Cop National SBA, and the other one is a lawsuit against Janet Yellen. That's the one here in Huntsville. So I would encourage, I don't have any email addresses except for a couple of people, but I think it would be beneficial for next week. The attendees to this meeting go read these two recent, within the last couple of years, where we have U.S. district courts come out with real good opinions, so good that the Treasury said, "Oh wow, we're not going to pursue this on appeal. We can't win." And so that's what they've done. They dropped this requirement for corporations and other business entities to report to the Treasury Department all their owners, those that have a beneficial, not just direct ownership interest, but anything that's just beneficial, just to the slightest degree. If somebody's got a beneficial interest in this business, we want to know about it. And that arguably applied here in Huntsville, Alabama. But, we had one judge here in Alabama said, well, no, Uncle Sam didn't have that power. And so, if you go over and take a look at my website, and I think, as recall, I think I've got a file that talks about the limits of federal government. Some real important cases. So if you want to, see some Supreme Court cases, and I cite these cases at times, and I find some people they never knew about these cases, but once they do, they say, well, gee, I was unaware of this, this lack of authority. And I think it's real important for people to have a good understanding of the lack of authority, the holes of the federal government. Too many people just run around, especially the government. They want we got a whole lot of power. Well, I think it's real important for people to understand the limits of the federal government's power, as well as state governments.
Looks like Arnold's got a hand up.
What's his question?
I don't know.
Hey, let me try to get him unmuted.
So, Larry, basically you're looking from outside looking in, right?
Yeah.
Go ahead, Arnold.
Okay. My name is Arnold Flores. Thank you very much. I love being on this forum. I'll give you a quick sentence and I'll ask my question. So the quick sentence is that I sent my revocation of election into the IRS. They responded within 30 days, and their response is, there is nothing further for you to do. So I revocated. The second part of that is if they do try to implement an administrative act against us or an administrative penalty, how does the Chevron deference or the Jarchese versus SEC help us?
Well, I don't know. First, this patriot theory, tax theory about revocation of elections. There is a procedure with that name that is more limited and not necessarily encompassing what the patriot promoters say it is. But I've reached the conclusion, even though it's just surmise on my part, that revocation of election is these people think, well, you don't owe the income tax, so you have elected. Well, that is a way to think about it. That's a pretty apt description, but it's used for a different process. But that's a pretty good description. But I don't think that you received that because you presented certain argument in your complaint saying, well, gee, I'm not subject to the income tax. That would be right?
You know, that's very astute. Yes, that's correct.
Okay.
I cited laws, I cited regulations, sent the letter in, and the IRS did respond within the 30-day proper timeline, saying there is nothing further for you to do. I'm happy to share that letter from the IRS with the
Well,
group. I
that
mean,
would be
or
good.
with
It'd
you.
be good to see how long it lasts.
Well, that's why I'm asking the question. And the second part of that was Jarchese. I've been reading Jarchese versus the Security Exchange Commission. The Supreme Court decided that the administrative state cannot adjudicate without getting a Seventh Amendment trial by jury. And so I'm wondering if that helps us in these type of
Yeah,
instances.
it's going to be. I mean, I'm expecting a bunch of lawyers to start making those arguments about, gee, I'm entitled for a lot of these battles they have with the government, entitled to litigate and get a jury trial. So it's going to evolve. There's going to be more battles. There's going to be this. There's going to be a search. Typically, when you have a principle come out like by the Supreme Court, like in that case, it's going to take. It may take as much as 10 years before you roll through a bunch of administrative hearings, and now a new field of law is developed. So that's where I see that coming. But it's going to take some time for people to, people in the tax movement could do the same thing.
Yeah, may I share two more things? So the two
Sure.
more is my friend and I both did this at the same time last year in January. After we submitted our revocation of election, I received a response, said nothing further for you to do. My friend has received 3 responses in 2025 stating we need 60 more days. In parallel, what we did, we also sent letters to the IRS requesting our 2024 withholdings. With me, they've ignored me. With my friend, he got all his withholdings back from 2024. He actually got a check from the IRS.
Wow. Good. Well, all of this can change, and this is what I'm kind of worried. If we had an election now, I would think if the Republicans might win, but there's a distinct possibility that if the political makeup of Congress changes in favor of the Democrats, I'm thinking you're going to be things are going to change dramatically. If the Democrats are at least able to stop the Republicans, or if the Democrats gain power, they've already indicated, boy, they want to, they're acting, they want to act like that blooming New York mayor.
Mondami.
Yeah. Tax.
I have a comment.
So, I think right now the pulling away of enforcement by the tax boys is because of Trump. And once Trump is gone, I think you're going to come back in. Hey, look what this new governor of Maryland. Wow. Katie bar the door, she gets into power, and boy, she's already imposing these schemes for raising wealth from the people.
May I comment something on Arnold's
Go ahead.
subject there? We had similar things happening. I don't know if you were in from the beginning of the show today, but Pete Hendrickson, David William displayed similar letters, and they last about 2, 3, 4 years. We have a gentleman on our tax chat that filed W-4 exempts, and after 6 or 7 years, if I recall correctly, he started receiving lock-in letters. So it's not a guarantee that what you got within the last couple of years are going to be meaningful. And these are apparently administrative solutions. Maybe they're too busy. They'll just send something, and then they come back and say, "Oh, sorry, we made a mistake. You owe us this plus interest," or stuff like that. It's not unheard of. So I'd be very careful.
Yeah, and comment to that, there's another person too that filed the same letters 2 years before, or 3 years, 2 years before I did in 2023. she received a tax bill from the IRS for $210,000, and she's been fighting it since 2024. And then it went to different agencies. They sent it either to Texas, then to Utah. It just kept going across the country. The IRS just kept bouncing this letter over. And I talked to her, and she said that she received a letter that says there's nothing further for you to do. The debt is forgiven or something like that. I forget the wording they use, but somebody mentioned an abatement. I don't know what that is, but she's off the hook for that $210,000. She actually showed me the letters.
It would be good to catalog all these letters.
Yeah, I've got copies of some of them. I've been cataloging some of this stuff. That's why I wanted to join this group, because you have a big trust in our movement, and I want to be a part of this. But I'm happy to share the letters. I've tried to reach out to Joe Bannister, but I guess you guys are busy, so I can send them. But happy to share them with the group.
Do you have my no mass tax chat?
I do.
Okay, great.
I just saw that one.
All right, good. If you link
put that
there,
in the
then
chat, Mark?
yes, I already linked that, and I receive all these. I send them and I share them with both Larry and Joe.
He put it in, and I downloaded it and put it on my desktop. I got into your Telegram, Mark. I appreciate it.
Yeah, I saw that. Good, got
Mark,
it.
what's the Telegram? I think I have Telegram on my phone, but what are you able to do as far as communicating with a large group?
Think of Skype. The same thing. Telegram took over basically the functions of Skype.
Okay.
The same way, very simple, very easy. Once you get used to it, it's quick. You can do conference calls. You can exchange documents in real time, post everything, every format, every medium.
So you send out a link to, how do you get people to join up?
Yeah.
Like, to let them know. Oh, because they're going to join the group. No mas taxes.
Tax, correct. No mas tax chat.
You let everybody know, hey, we're going to meet at 7:00 Pacific tonight.
Yep. That's exactly what I did tonight.
All right.
Once you send that link, boom, everybody it has it. And it's instant. It's Telegram, fast.
Well, I'll try to join up like kind of between phones, substituting phones, but I'll try.
Well, you can do it on your laptop, on your desktop.
Okay.
Yeah, if you have a Telegram account, you just click on the link that I sent there in the chat. I posted it in the chat. You click on that, it'll take you directly, and you can join.
Okay, great. Well, we're probably going to wrap it up. Go ahead.
Oh, you're going to wrap it?
Go ahead, Tapster.
Mark, just Telegram, basically it's constant communications. I mean, I get stuff from the groups I follow constantly. Is that the way you do it, or do y'all try to have a set up meeting 1 or 2 times a week where everybody gets together? Just a quick overview of how you do it.
Our group happened because the people in our group were clients of David William, who advocated the 1040 NR, and he disappeared. So, story short, I mean, make it a long story short, I decided to see if people want to still communicate, because the forum was no longer available. So I opened up a forum, no mas tax, and everybody that DM'd me got on this forum. So now we're communicating, we're exchanging opinions and share information amongst each other, and we kind of know each other now. We know each other's circumstances more or less, and we bring the new information, we share. And if we want to have a conference call, I set up a conference call where I can do a presentation and they can talk. We can do just like Zoom.
Okay.
But it's within the group.
Gotcha.
It's not a public forum.
Okay. All right, I'll follow it, and then next time I see y'all pop it up there, I'll make sure I get in there. Can we do it earlier? I have a terrible time. I fall asleep by the time Joe opens his up. I'm joking. I know you gotta call it, Joe. You're running out of time.
Yes. Tonight we do, guys and gals. So I just got to go through the typical housekeeping because there are people that watch the archive of the show, and so it's good to kind of go through this, especially for them. But it's a good refresher for everybody here.
I got a quick technical question, Joe. How do we save the chat? From somebody in the group asked, how do we save this chat for those that were not able to participate tonight?
Well,
A
is there
copy
a
of the
way,
chat.
if I get you the chat, Mark, are you able to chat it through your Telegram group?
Well, I'm talking about the chat in the Zoom here. How do
That's what I
we
mean.
get a
Like if
copy of it?
I get a download basically of the chat, everything in the chat. So then it's a file. And so I can email it to you and you can distribute to your group.
You can, but I have a hard time getting your emails for some reason. I had a problem with Larry today. I didn't get your invite. I got it through Larry. But if you say you have a Telegram, you click on my invite, you can send it directly to me on Telegram.
Okay.
Or send it to Larry, and then I'll get it through Larry for certain. But I can follow up with you if you're doing this next day. I'll call you tomorrow and see if you got it for me or not.
Yeah, but I definitely, I just don't really have a way other than like putting it in one of my email blasts.
Got it.
Which I don't think I want to do.
Yeah. I want to do that for our
group. It's just a matter of how you want to disseminate it. But certainly I would think your NOMAS group would be a great place to have that available to those that want it.
Yeah, there are people that couldn't be here tonight, and they wanted this saved, and I don't know how to do it on Zoom because I don't have the Zoom program.
Sure. All right, well, let's just go through this quickly. So go to as far as getting to Larry's website, go to the search engine like Start Page, type in Beecraft Briefs into the search box. That'll take you to this highway.net website, and that will take you to the Dixieland Law Journal, and Larry has all the hyperlinks here. Here's the taxation one, which we talk about a lot, but there's Federal Reserve, money and economics, even Second Amendment stuff, all kinds of great resources there for Larry. He also has links, I think this top one, Larry, links to the constitution.org website where you can actually download, view and download the various regs and statutes for each of the tax acts that we've talked about very frequently on the show. Moving on. So in my website, agentfortruth.com, you can send me a message down here at Contact Joe at the bottom. Can't promise that I can respond personally, but I probably will at least see what you send me. I also encourage people to go to the blog articles because I wrote a blog article on what I call the 1040A scam. And I think it's really important for people to read this blog post. Also watch these videos that are up here at the top so you can see exactly how the IRS scams their own computer system to get assessments against people that don't file, like myself. They did it to me personally. Here's the IRS notices to prove it. Anyway, so I think you really get a kick out of that. I hope you'll share it with people. Because in addition to freeing ourselves from this evil tax, it'd be nice if we can get, tens of millions of other Americans to be with us, and that way the IRS can't pick us off one by one. So I think I really try to encourage people to spread the word about these things, and such as this article and Larry's website. Also, my Twitter, x.com is at Joseph Bannister at Joseph Bannister. There's only one N in my name. We're the nonconformist wing of the Bannisters. So there's only one N in Bannister. And that's about it for housekeeping.